Guys, please be so kind and turn off your microphones, please. Just to hear each other better. Hi guys, I'm very happy to see you here. I hope that you are fine and enjoyed your amazing tour yesterday. And today I decided to start our session about international criminal law from the excursion that you have already attended. So probably we will try to remind you some interesting places that you have already visited, and I hope that we will have a small game, an interactive game. I will show you the pictures and then you will answer what is the place of interest. Do you want to play? Guys, are you okay? Do you hear me well? Just type plus. Or play what? Perfect. We will play a game, a nice game about. By the way, have you read the chat in our group? No one answered, but I attached several films about Samara region, and now I'd like to play a game about Samara. So the topic of our game will be Samara, and then we will turn to international criminal law just for the start to make you more. Oh, thank you, Megan. Thank you very much. I am very happy that you have already seen the film. And for the very beginning, we will start the game. Okay, so I will share the my presentation. One moment. Нет, не хочет. Так.
Почему?
Не знаю.
А кто программа?
YouTube.
Не весь экран, а одна программа.
Сюда?
А можете немножко камеру ближе сделать, Данила? Чтобы было видно только спикера.
Окно программы.
Сейчас все сделаем. Выключите микрофон пока.
Я не вижу. Да. Okay, guys, so let's start our small game. Now we will try to have a look at Samara sightings. So please be careful and try to answer the questions. I think that someone has already seen the answers, but I hope that you will do your best and you will solve them, you will answer my questions by your own. So let's start. What do you see on this photo? You can turn on your microphones or you can just type. Do you remember this place? What is it? Please, you can turn on your microphone and we can make an interactive.
Is it the drama theatre?
Yeah, perfect, absolutely right, Megan, thank you. Let's turn to another picture, please. And what do you see here? Not far from this place, you see another interesting building, very beautiful, where one family lived. How it was called? Do you remember? I will give you a hint, a small hint. This museum belonged to a family, Kurlina family, and now it is the Modern Museum or Museum of Modern. Let's come to another picture. Do you remember this beautiful place which you enjoyed, as far as I remember, according to your talk in the chat? Do you remember it? Any ideas? Come on, answer the questions. We are going to talk about serious problems, so we have to be active now. I see that Monica typed something, please. Oh, okay. Do you remember this place? So I will give you an answer. It is the Iversky Women's Monastery. The next one, do you know this river?
The River Volga.
Perfect, Megan. Thank you so much. This is the River Volga and the embankment of the Volga River. Okay. Next idea. Okay, perfect. Thank you very much, Haru. That's the best answer. Absolutely right. Stalin Bunker. We don't know if he had already attended it, but still we know that it was built for him during the Second World War. Thank you very much, Haru. Then the one. This, I think you haven't seen this place, but it is very beautiful and it is one of the biggest railway stations in Europe. So if you arrive in Samara, you will attend this beautiful railway station. And the next one, I don't remember. Pedro, please. Perfect, Monica, absolutely right. This is the drama theater and Chapayevsk monument in France. Perfect. Thank you very much, Monica. Nice that you remember. Okay. The next one. Do you remember where Julia made
Is it the White House of Samara, I think they said, where all the laws are made? Is that correct?
No.
Oh, sorry.
Okay. And here's Daniel. No, Pedro. Oh yeah, this is the main square, of course. This is the Kubyshev Square, which is the biggest square in Europe, with the monument to Kubyshev in the center of the square. And by the way, behind the monument, you can see the Opera and Ballet Theater. So, Monica, that's correct. The next one. So I guess you remember, but I don't know. Did you remember the name of this monument? I said that someone is writing. No, Haru is writing. Lada, absolutely correct. That's the name. Perfect. You have a good memory. Thank you very much, Lada Monument. Good. Then I guess everyone knows that this is the rocket, right? The rocket, I guess you enjoyed it. And there is the Rocket Museum that is very interesting, where you can get to know the history of Samara region, especially according to rocket building and space engineering. And the last one, any ideas? Do you know what is it about, these photos? These photos, what do they show? Anyone? No one remember? Because no one has attended this place. This is our university, in fact, Samara National Research University, where we are sitting right now and where we are working for you right now, because this is our main building. So hope that soon you will attend this university and you will visit Samara University and attend many of our courses and programs. So now we are going to start our course, International Criminal Law. You know that international criminal law is very important and it is the part of international law. Now I would like to share the presentation. One moment, please. Сейчас хочу. Так. So now we will have a look at our presentation, and we will talk about international criminal law and the principles of international criminal law. In fact, I would like to start with the questions of course, public international law. As you know, that international law appeared not far away, because we follow the Westphalian system. Does anyone know what is a Westphalian system? I guess no one types, so I will tell you some words, because the international law is based on this system that was established in 1618, so more than 300 years ago. And in fact, the Westphalian system was established after the 30 Years' War. It took place in Europe, as far as you remember. So the main principles of international law appeared also in Europe in the 17th century. And when we are talking about international criminal law, of course, we should know what is the basis. And the basis for international criminal law is international law for sure. And when we are talking about international law, we should understand that, of course, international law provides the general principles that governs the actions of states and how states interact with each other and individual citizens. Public international law involves rules, principles that deal with the conduct, rights, and obligations of states and international organizations, as well as dealing with the relations among states. And of course, we should understand that international law was established to provide the necessary regulation between states, the main principles of interaction between states. And when they break the rules, so they have to follow the responsibility, because all the principles are discovered in the international documents, such as, for example, treaties, conventions, and so on. And we will talk about the sources of international law, and especially international criminal law. And then we will have the debate to discuss the principles of international criminal law and international law, because they interact with each other. So we know that international law is broader than international criminal law. That's why we have to come to international criminal law. And when we talk about international criminal law, of course, we know that it's a subset of public international law, and it has, of course, its own subject, individual subject. And of course, the main idea is the responsibility of individuals. And of course, international criminal law is a subject of public international law that works to punish those who commit crimes of a more severe nature that often attack large groups of people. And we will talk about the types of the crimes, because this is very important for us, because you know that there are many crimes that are committed right now, for example, and there are many disputes about the ways of judging. For example, we will talk about International Criminal Court and International Criminal Tribunal, and we have an idea to discuss the difference between these courts, the ways of establishing these courts, and the ways of behaving in these courts, how to stand trial. So we have to understand the difference. And of course, when we examine international criminal law, we should understand that, of course, it includes laws, procedures, and principles relating to modes of liability, defenses, evidence, court procedure, and so on and so far, because it is very important to know how to behave at International Criminal Court. So we have to discuss, of course, the sources of international.
Olga, no te veo. Pero ¿por qué no haces refresh?
Sorry, please. Will you be so kind to turn off your microphones? Thank you very much. So, when we talk about international criminal law, of course, we understand that it is a relatively new body of law, because it was established mostly after the Second World War, when the conventions took place, and of course it regulates the main crimes like genocide, crimes against humanity, war crimes, and the crimes of aggression. Of course, they do not include piracy, terrorism, slavery, drug trafficking, or other international crimes. They are criminalized under the national legislation. And we should understand the difference between national legislation and international legislation, for sure, because it is very important for us, in fact. And of course, international criminal law includes victim participation, witness protection, mutual legal assistance, and cooperation issues. Talking about these sources of law, for sure, we should know that they are very important, and the states should follow these sources if they have already signed them. And of course, the sources of law can sometimes overlap and have a dynamic relationship. For example, we are talking about the treaty. The treaty can, if we are talking about the treaty, there are different types of them, and we will have a look at the most popular. The judgment of an international court may influence the development of treaty and customary international law. Generally, international and hybrid courts. Nice to meet you, girls. Thank you for turning on your camera. I'm very happy to see you here. Thank you. So when we are talking about hybrid courts, they use, of course, treaties and customs mostly. We have several types of sources of international criminal law. And what are the treaties? To understand these sources of law, we have to look at some of them. And the most popular treaty, which of course everyone knows, is the Rome Statute. So treaties, what are they? They are agreements. Agreements usually in written form. So you know that we have written law and unwritten law. But for our system, written laws are more popular for sure. And treaties are agreements creating rights and obligations usually between states. Some treaties also create duties and provide for the protection of individuals. And international criminal law has many treaty sources. These range from obvious examples such as the Genocide Convention and the grave breaches provision of the 1949 Geneva Conventions to relevant human rights treaties and treaties that are not as widely ratified as the Geneva Conventions. So we should remember that all the treaties should be ratified, other way we cannot use them, the government cannot use them. And the most important treaties are the Rome Statute of the International Criminal Court, the additional protocols for sure, Convention for the Protection of Human Rights, Pact of Security, Stability and Development in the Great Lakes region, Convention Against Torture and other cruel, unhuman, degrading treatment and punishment. Of course, the judgment and the legislation is revealing fast. And of course, many countries are on the way to ratify, but that depends on the country for sure and on the level of the country, how much it is developed for. In jurisdictions where treaties cannot be direct source of law, they often can serve as aids to interpretation of other applicable law. Of course, in some jurisdictions, treaty law is the main source of international criminal law, as I have already told. For example, if when we are talking about the Rome Statute of the International Criminal Court, it is a treaty of primary source of law for that court. So when the judgment goes, the judges use these treaty, this statute. Of course, the statute of the International Criminal Court is very important for all of our countries because we use it. However, the International Criminal Treaty of Yugoslavia and Rwanda treaty law is less important than custom as a direct source. So here we should remember the difference between International Criminal Court and International Criminal Tribunal. What's the difference? You know that sometimes people commit war crimes. They are very cruel, for sure, and sometimes even nations suffer. So, according to this, the United Nations organize the International Criminal Tribunal, and the most famous tribunals are the International Criminal Tribunal about Rwanda, about Yugoslavia. I guess everyone knows about these cases. And of course, the sentences that were provided by this court, we know and we follow them because they have the interpretation of the main ideas of international criminal law. For example, the International Criminal Treaty of Yugoslavia has laid down clear rules for when treaties can be a direct source of international criminal law, at least at the court. Holding that treaties can be applied that were unquestionably binding on the parties to the conflict at the time of the alleged offense. So this time we should use this treaty for sure. I would also want to focus your attention on customary international law, because of course the treaties are we have in documents, in written documents, and customs we should follow. And custom is generally understood as consisting of state practice and opinion juries. So we follow the principles of Roman laws, as you remember, because in Rome, the main source of law was custom. Everyone knows about that. So here we also follow custom laws for sure. And the state practice must be consistent, uniform, and general among the relevant states, although it doesn't have to be universal. Of course, opinion juries can be defined as a general belief or acceptance among states that a certain practice is required by law. Treaties only bind states that parties to them, whereas the general customary law binds all states and local custom binds as few as 2 states only. So in general, and depending on the circumstances, evidence of state practice and opinion juries may include, and we can find some parts of it: diplomatic correspondence, official policy, opinions of government, legal advices, military manuals, and so on. That's why we use these source of law only when for example, it is necessary, and when the parties, when the states follow these customs, because this source of law is not written. I also see the questions. Thank you very much. You can type them, and I will answer at the end of this part of the course, because we will have a small break later. Thank you very much, Monica. I'm very happy that you listen carefully. That's very important for me. So we have, of course, custom and legality principles. For sure, we will talk a bit about them. We follow general principles of law, and of course we follow judicial decisions and learned writings. And in fact, we know that we follow judicial decisions because even we can cite them in the other cases, because it seems like precedent law. So the cases are printed, all the cases are printed, and we learn them, in fact, when we study international criminal law with our students, because we try to understand mens rea, how the judges find this mens rea in the human's behavior, and it is very important to provide the penalty for the punishment. That's why we should understand the sources of international criminal law. Of course, there are different types of crimes which can be committed by persons. And the first crime, for sure, is one of the most is very awful, and this is genocide. And this crime appeared, of course, in the Second World War. All of you, I guess, remember the Nuremberg Tribunal. So it was about Nazi, and then the other tribunal followed about the Japanese penance. And of course, genocide is one of the most important ways for us to understand how much damage can war bring to us. That's why, of course, this crime was established, was put on the first place. We also have crimes against humanity, and the notion of crimes against humanity was originally created for the purposes of prosecuting the main Nazi defendants at Nuremberg. And the name and the understanding of these crimes we will have a bit later, because the definition of crimes against humanity is broader, for sure, for example, than genocide. But genocide is on the first place always. War crimes, of course, we will discuss, and crime aggression. So let's start with genocide. Now, of course, as I have already mentioned, this crime was described at the International Criminal Tribunal of Round Decision, sentence, of course. And we can have a look at the Rome Statute. And if we analyze Article 6, we can imagine everything what happened to people during the Second World War. So everything started from killing members of the group till even forcibly transferring children of the group to another group. And when we are talking about genocide, I guess now there are no such cases in the International Criminal Court, but they have cases about crimes against humanity, and we will have a look at some cases. The second part is about crimes against humanity. Also, we need to have a look at the Roman Statute of the International Criminal Court. According to the Article 7, you see different types of crimes, and sometimes they're in parallel with the genocide. But still, crimes against humanity are broad, as I have already told, because they combine different types of crimes, as you see, even torture, rape, sexual slavery, and so on. But still, sexual crimes people try to put in a special group because they have another mens rea. That's why we have to talk about them later. So crimes against humanity. Still, the criminological element of crimes against humanity is thus increasingly a unique attempt to protect humanity, understood as both the collectivity of human beings. And what makes human beings specifically humanless? That's why it should be understood according to the trial. And they have to defend, of course, the positions for sure. Then we can talk about war crimes. The oldest in the history of international criminal law, having been persecuted domestically on the basis of international conventions since the First World War. So, what constitutes a war crime? It is defined by the various rules of international humanitarian law relating to the use of certain means and methods of combat or certain protected persons. We know that war crimes were committed, of course, for example, in the second part of the 20th century, but still some scientists say that many war crimes are committed even in the 21st century. Probably when we will discuss the principles of international criminal law, we will try to understand what is the war crime, and we will try to understand when the principles of international criminal law can be broken. That is very important for us because we should understand when the person will stand trial. So please remember these slides. I will of course share my presentation with you, so no worries about that, because everything we do is for you especially. So war crimes are committed by the government bodies mostly, and when we will talk about war crimes, we will talk about the cases of, for example, Slobodan Milosevic, of Mlatko Radic, Mira Karadzic, and so on. So these are the most famous, I guess, but don't forget about other penance for sure, but of course you should border war crimes and other international crimes, and the crimes that are under the national legislation. For example, as we have already talked about terrorism, as you remember, because the penance of stand trial in their country, not in the International Criminal Court. So that's the difference between war crimes and national crimes that are committed under the national legislation. And here you can have a view at the main conventions and additional protocols that establish the standards of treatment for example, for the dead, injured, sick people. They provide the obligations of states and so on. So, of course, here you see only the main treaties, but you can have a look and understand who is protected under these treaties and when they can be protected, in which situation, because these ideas need to be defended at court. And here is the second part of the table. You also see the additional protocols to the Geneva Conventions, and you see also the ways of protecting and who are protected. You see that mostly it is connected with persons, mostly that suffer from the armed conflicts, because of course international armed conflicts many people suffer from them even nowadays, because we have war conflicts, and I guess probably your neighbor countries, some of your neighbor countries also have war conflicts. For example, if we are talking about Europe, not so much time passed after the conflict in Yugoslavia, for sure. Now in the Ukraine, as you know. So as far as you remember, several days ago, there was a conflict in which country? Do you listen to the news, guys? Hello? Do you remember?
What was the question? The conflict of what?
Yeah, do you know that several days ago there was a conflict between two states in Europe, in fact? Which states?
Olga, you know this. Oh, she's muted.
In China.
In China? No, everything's okay with China, no worries. It was, I guess, this week it happened, there were some conflicts between two nations and two countries. No, not India and China. I don't know why you thought about India and China. I, as far as I know, nothing happened there. But Lucia, please, you are typing. It's we can say that it is exactly Europe, in fact, but it is between Europe and Asia for sure, and Russia borders these countries as well. That's why we are a bit nervous about this conflict, of course, because we border them. I see that several guys typing. You can turn on your microphone and answer if you have any ideas, because this situation is going on right now.
Now you hear me?
Yeah, perfect.
Oh, well, maybe you're talking about Serbia and Kosovo, or you're talking about, Moldavia and Transnistria. And then you're talking about Ukraine and Crimea too.
Perfect. And you know,
Georgia in 2008.
Yes, absolutely. Thank you, Olga. And one more. What is going on right now? But I know that, of course, the situation in former Yugoslavia between
Croacia and Bosnia.
Sorry?
Croacia, bueno, Croacia and Bosnia between the most part reached this conflict in 92, I think 92, 94. And well, we have genocides also in Glina, inside Croatia with Serbians too. And well, we have Nagorno-Karabakh, but this is another.
Yes, absolutely.
Thank you. Thank
you. Perfect, Olga. I guess you know the region so well. Probably
He knows everything.
No, I love to study. I love Chechnya is one of example now, but it's inside Russia. It's not between two countries, but it's inside Russia. But I think the things are down now. After Dagestan incident, I think it's more quiet.
Yeah. It was an inside conflict in the 90s, in 1990, for example, in 1995. Yeah, so there was the inner conflict, but it wasn't an international conflict. And right now, I see that who typed there was conflict between India and China. Yes, there were conflicts, but I guess they are not are going on now. That conflicts were, I guess, many years ago, and I didn't hear anything in news. Anyway, for now it is between Armenia and Azerbaijan.
Azerbaijan. Yeah.
And we are very sad about this conflict because it took place many years ago, mostly I guess 20 years ago, and now it's going on, and that's why we are very sad. And in fact, yesterday or 2 days ago, there was a conflict even in Moscow between representatives of these two nations. We were shocked. That's why you see how the relations between states also influence the relations inside the other country, even because this conflict was with also guns and so on. That's why we were very sad about it. So thank you very much, Olga. And you're perfect, and thank you very much, Hu, because I see that you typed about the conflict. Yes. Oh, really? You are talking about the conflict between India and China a month ago. Probably, but we haven't seen it in news. Olga, you know everything Lucia said. Have you heard it?
I really like to invest, read and do researching. I love really the relations inside the Euro-Asiatic relations. Okay. Yes, thank you.
Thank you. So, dear Hu, I think that probably, of course, we believe you. Probably it happened, but we haven't seen anything in our news. So, thank you that you informed us, because we know that it is a very deep conflict that started many years ago, many centuries even ago. Yes, we all know. So that's we hope that it will finish, but no one knows, as always. So of course.
Excuse me, ma'am. Am I audible?
Yeah.
So this Armenian-Azerbaijan conflict is the root cause is Turkey, and since the Syria war has started, Turkey has been playing a very confusing role. It is very difficult to predict Turkey's intention and attitudes since the Syria war started. So see, presently Azerbaijan and Armenia is just one of the twisting attitude and activities of Turkey. Turkey playing a very critical role because of its high noble intention. Let me say, because he want to be the boss or whatever. So Turkey may Turkey probably in future be the root of all problems with NATO, with Europe, with Asia, because it is being an opportunistic country. It always focus its own interest. So it is also a part of NATO. It also is a part of trying to be close to Russia for being opportunistic. At the same time, making problem with Greece and also European Union. Recently, the monument of Orthodox monument in Turkey, they want to convert it into Islamic something. So Turkey is playing a very critical role, even though Turkey has a very good potential to play a very constructive role. But since last 1 year, what we have been watching and observing, it is not playing a constructive role, rather a cunning role.
Okay.
Benefit. Azerbaijan was provoked by Turkey, because Turkey is they are Muslim dominated country. So Turkey blindly support that, but Armenia is supported by Russia. So Turkey can we have a lot of potential to play a constructive role since the Syria war, but till today evidences are confirming that is playing a rather a destructive and cunning role, being opportunistic. So that's the pity.
Oh, yes. Thank you very much. Thank you for your commentary. This is very important for us, and I'm very happy that you understand the political background of this situation, because of course international law is very close to international policy, and that's why sometimes we provide lectures about international law and international policy. But today now our main idea is just to have a look at international criminal law, not touching international policy because there are too many controversial questions while discussing these topics, and we won't get the only answer, the only one answer, and that everyone can agree. That's why I hope that we are very polite and we respect each other. That's why I hope that we understand each other perfectly. And now we have to follow our agenda, of course. We know that we are talking about international crimes, and we have to talk about, of course, sexual crimes, because as I have already told that sexual crimes also belong to international criminal crimes, and they are, of course, one of the most significant substantive developments of international criminal law since the 1990s. And of course, it is about increasing recognition of the role of sexual crimes in genocide, crimes against humanity, and war crimes. And of course, they were established in Statute of International Criminal Court in Article 8, Section 2, and you can have a look at sexual offenses for sure. So of course they are very important for our understanding. And the last one, but not the least for sure, is aggression. Aggression is also the type of international crimes, and when we are talking about aggression, it is a specific crime when someone plans, begins, or carries out an act of aggression through the use of state military, for example, military force, and that violence is the charter of the United Nations for sure. And aggression and war crimes share the fact that they both relate to the regulation of the use of military armed violence, although they do so from two very different angles. And it is about criminal violation of what is known as the use of ad bellum, legality of resort to force, whereas war crimes are criminal violations of the jus in bello. So, of course, we have to understand the difference between these two types of crimes for sure. And to understand criminal law, for sure, we have to understand its components. And firstly, international law rules over the relationships between responsibilities of interacting countries. Of course, criminal law, international criminal law, establishes what is and is not considered a crime, and then sets up respective punishment for those crimes. Of course, you know that the punishment should be absolutely individual, and the principle of individualization of punishment is one of the main principles in international criminal law. You know that firstly, there was crime against peace, and crime against peace was the first type of aggression, of crimes called aggression, and described as the mother of all crimes at Nuremberg. I cite the sentence because, of course, we cannot say that some crime can be the mother of crimes, but it is written in such a way. So, crime against peace. The prohibition of war by the Bryant-Kellogg Pact of 1928 was seen as having solidified enough to have become a criminal prohibition under international law, and all the Nuremberg were accused of having conspired to disrupt international peace. And after talking about international criminal law, about types of international criminal law, I would like to share some ideas with you. And these ideas are about the difference between the international law principles. For example, we have two principles, as you see: the right of people to self-determination and the principle of territorial integrity of a state. We have mentioned, and you have already mentioned, several conflicts, and most of them are about nations and the idea of the nation to provide the individual state. And I'd like to divide it into two groups, if you don't mind, and to make a debate and to find the answer to this question, because we have to understand, do they conquer between each other? How these principles can interact? What can you say about it? And I provide two groups of norms, legal norms. The first group is about Charter of the United Nations, and here you see that in the Article 2 it is written that all members, right, shall refrain in their international relations from the threat or use of force against the territorial integrity. So the main idea of this part of the article is territorial integrity. And the other idea, also provided by the United Nations in its Declaration on the Rights of Indigenous People, is about self-determination. You can see that in several articles it is written that indigenous peoples have the right to full enjoyment, the right to self-determination. So, please, I'll do it indirectly, absolutely, and you'll be in two rooms, and I will give you, I guess, 5 minutes. I guess you won't need more or more. Olga, you want more minutes? I guess we don't have them.
Her microphone is turned on by accident. She forgot to turn it off. I've been trying to tell her, but no, mi cámara está prendido.
Okay.
Okay.
So,
I'm sorry, I don't know how to put it off.
it's okay, no worries. So,
Apaga la parte de abajo donde sale el micrófono en el circulito. Ahí la apagas.
Yeah.
So I will divide you into two groups, and I will give you, I guess, 5 or 7 minutes. I guess not more. And the first group will defend the Charter of the United Nations, and the second group will defend the Declaration of the Rights of Indigenous Peoples. And I would like you to compare them and to see what do you think about these two principles, and can we combine them? Can we use them together? Of course, so they're equal for us, because all the principles of international law are absolutely equal. But still, you see that, for example, the United Nations use the principles according to some political views, political ideas, and something else, you know. So please be ready after these 5 or 7 minutes to defend your thesis. And we will discuss this problem because these two principles also can be the beginning of the international crime, the crime like war crime we are talking about. Was the task clear? Was it the task clear?
Yes, the task is clear. Thank you.
Thank you, Megan. Okay, I will try to divide you. Two groups. Okay. So 7 minutes. That's enough. Indirectly. I won't be with you in this room. So okay, let's start.
You are now muted.
Excuse me. Am I audible?
Hello. Yep, I can hear you, but I don't see the professor.
Oh, me too. Thank you, Daniel, for your confirmation. But I either can't see or listen any conversation. One of our colleagues from China probably was discussing something. I listened that, but after that I got lost.
Yeah, it looks like we got back to the main room, which
Yeah,
is this one.
I think he kicked us out of the breakaway groups. But like you say, the professor's not here, so.
Our colleague was explaining a very nice way about something, but I couldn't listen up to the end, unfortunately.
Yeah, that was Hu Bing Ching. I'm sorry, I don't know how to pronounce that. I'm sorry.
But it was very nice the way
No,
she presented.
there's a professor.
Yes. Am I audible, ma'am?
So, sorry for coming into your rooms. I decided to have a look how you are working. In fact, I'm very happy that you discussed the ideas, and now I'd like to hear the speakers and the positions of the speakers. Please, you are very welcome, and the speakers from two groups, you can start. Please, who was in the first room, and please, when you log in now, don't forget to choose the microphone, because other way you won't have the opportunity to speak, and I would like you to speak for sure. So if you are with the hearings only, please re-entry and choose the microphone and please talk because we want to see how you can stand the position, probably which you do not share. And by the way, I would like to know your opinion, which position do you share? The position of the Charter of the United Nations or the position of the Declaration? So please take your take the turn. So who will start? Dear Olga, you cannot speak because you didn't choose the microphone. So you have to either log out and then log in, or you should turn on the microphone to speak. Oops. And while while you are trying, we don't hear you, Olga. Please to enter this room just now, the connection is not good. Okay, but I see that many of you re-entering. Perfect. And while you are coming, I'll try to answer the question. Monica typed about the principles of relativity work in the treaties of these tribunals. Is there any difference? Because they established post facto of the crimes. Of course, the principles, most of the principles, I can agree with you, Monica, you are right, because most of the principles were established after the crime was committed. That happened because you know that during the 20th century, the beginning of the 20th century. Firstly, there was the First World War, then the Second World War. So before this, there was no such idea to establish the principle of international law and to establish the principles of international criminal court and the ideas of procedure. So that's why I can agree that these principles were established post facto, absolutely. But still, they are used now, and these principles became written principles, and they were written in the treaties, and these principles were these treaties were ratified. And by the way, I would like to mention, I guess everyone knows the Declaration of International Principles. Do you remember? And here you can find all the principles of international law. And by the way, these two principles that we are talking about are also written in this convention, in this declaration, sorry. I decided not to put it into the slide because it will be so huge. That's why I just put 2 sentences. So,
You hear me? You can hear me?
yes, I hear you, perfect.
Oh, okay. Another example, I think, is the Kosovo with Serbia.
Yeah.
I think it's a big problem. It's not resolved, but I think Kosovo, Serbia, Israel, Palestina, with the problem of Cisjordania. I don't think Crimea, but for the other people, was like annexion, but it's different annexion than incorporation, you know?
Yeah.
Because there was a referendum and the people died to Russian citizens, you know? And when you take that examples, all people, for example, Ossetia, all people want the self-determination too, and one wants that, all want the same thing. Abkhazia, Ossetia,
Yes.
that happens. So they have to be so treated, because if you give one, all wants to have the same. I don't know. Yeah.
Okay, thank you very much. Sometimes we have problems with hearing you. Probably you can turn the quality from high to medium. So better, and you will be faster a bit. But I could hear everything. I guess that everyone have already heard, and of course I absolutely agree, because when one part of the country starts, for example, the referendum, like in Kosovo, then it seems like a chain, step by, and afterwards we won't see even the country. I guess now something like this happened with the USSR, with Yugoslavia, with Czechoslovakia. Do you remember? Now these are 2 countries, the Czech Republic and Slovakia. So it's the best example, I guess, because now we see that these steps are faster. So we know about Kosovo, we know about Abkhazia, Ossetia, and you have already mentioned about Karabakh, right? Olga mentioned did it. So that's a very important problem, in fact, because we cannot stop. It's like a disease, and the country is ill with this disease. Yes, Monica, please.
Thank you. Yes, it is very interesting what you are saying, and Olga gave us a lot of examples of this in the history of international relations, and she noticed some opinions, no? But the interesting thing, I believe, is that everything depends on the internal mechanisms of the countries, because there is no written, let's say, norm, no, that allows people the right of self-determination. So it is like a kind of ambiguity norm, and we can fulfill it of different conceptions. It depends on what we want, if the right of self-determination, or if we are in the position of the state and the government doesn't want to allow people the self-determination, no? Because I think that in Crimea, it was like very difficult, and from the eyes of the world, it was like, no, Russia like broke like the international rules, no? But from another perspective, it was not like that, no? And but yes, I think that it's one of the more controversial topics in international law, because we do not have a written norm, no, in this aspect, and everything depends on the right of the mechanisms. Let's think in Scotland, I think, no, they had the opportunity, and they didn't, let's say, won the separation of the territory. That's
What do you think about this case? And Monica, can you say which principle do you support more? We cannot say that we have already mentioned that they're equal for sure, but in everything you said, to sum it up, which principle is important? For example, which principle should be on the first, for example? Still, if
for my personal opinion, the right of self-determination, I think so. But let's listen to the other opinion.
Any other ideas? Thank you, Monica. It was very interesting to listen to you. Please, any other ideas? Yes, please. And who is typing as well? Okay, please go on.
I have a question. Did you actually pick the people from the two groups? Because I was kicked out of the room and I thought we were in a break. The last thing I heard you say was, you have 10 minutes, and then the room kicked me out. And I never heard anything else. And then I came back and you were saying that we had to break.
Oh, really? You had 7 minutes. You were picked out immediately? Really?
Yeah, I heard you say that, and then I was kicked out. And when I came back, you were saying that we had to debate, and I was like, what?
So, you know, the time was missed because you had 7 minutes. Sorry. I know that that's not enough probably for such a controversial topic, but still, we also have we will have one more debate, and I will put 10 minutes, so I hope that you will be okay. And if something is not fine, please write me in our chat, so I'll try to do my best to...
I would just like to know what group I'm in, so I can just make a decision. Yeah.
It doesn't matter, in fact, but okay. Please, you are welcome. You can provide your opinion. Please be brief, okay? Just several minutes.
Yeah.
Ma'am, I support Article 2 because the Article 2 is very realistic in practice. Even though Article 1 and 3 is more individualistic, but in this global setup, we can't focus individual Article 1 and 2. Rather, we have to follow a realistic scenario, and Article 2 is more realistic. And to defend my my statement, I'd like to bring into attention that there are some issues, global issues, which has been existing before the establishment of United Nations. For example, Palestine, North Korea. So these are the issues which has been existing before the establishment of United Nations. This has been a conflict till today. So, and if we territorial integrity, in my opinion, should be the first priority, because if go through individual identity, individual priority, self-determination, that of course that is more prone towards human rights, but at the same time a person individually can't represent, it's impossible to implement and impose a rule globally based on an individualistic approach. So every people from every state say, okay, we are different with respect to our color, religion, belief, practice, blah blah blah, so we are different. In such a way, it will lock down the whole national integrity.
Okay.
So this is why I do believe that, of course, Article 2 should be the first priority, taking into consideration of Article 1 and 2 within that country, and because there are numerous examples why so many people are migrating from one country to another country as a refugee.
Okay, thank you so much. So we understood that your idea in brief, that on the first, we should follow the idea about about territorial integrity, and the principle of self-determination should be described, revealed inside the country, and every nation should have this opportunity inside the country, and no idea for the state to torture any nation. So all the nations are equal inside the state. For example, in Russia there are more than 120 nations, in fact. So they interact with each other. It's normal. That, of course, there were some cases, as Olga already mentioned, in the 90s, but still were hard times, I guess. We also have some interesting views, and let's discuss the view of who says that personal rights are more important, or he mentioned that everything depends on the cultural background. For example, the US was built because American people wanted to build a country to defend personal freedom and rights, and to make sure the government doesn't have possibility to deprive those rights from them. So in the US, personal freedom is more important. But still, what will happen, or can you even imagine that one state, for example, I don't know, Florida, will say goodbye? Can you imagine this situation? I guess it's impossible for the states. Do you remember how was this country built? As far as you remember, at the beginning of the 18th century, the US 13 first states, even they bought the other states. For example, Louisiana, and it was called the Louisiana Purchase, as far as you remember. So they bought Alaska. Russia sold Alaska. So but they bought the other states. That was the first idea in our human society, in our history, when the country bought some territory from another country. But we don't imagine what will happen, or can it happen right now. Does anyone want to sell any territory? Okay, please, you have a question?
Madam, I opine that what our colleague suggested, I also agree. But unlike the country, in true sense, it is the responsibility of the country head and the country rulers or country administration to take care of individual person and ethnics and groups and cultural participants. It's responsibility, moral, social, national responsibility of the ruler to take care of individual of a group. But unfortunately, we can't expect this is not happening in reality. Unlike civilian government or democratic government, if you take out that, there are 40% country in the world is a democratic setup and civilian government. But if you exclude that, if the ruler is like a lifelong ruler or long-term ruler, or if the country is ruled by a single-handed person and or a ruled by army personals, then unfortunately we have been observing individual people's rights and individual people's dignity, individual people's wishes are crossed, unfortunately.
Yes, okay. Thank you so much. Yes, we got your idea, and we also listened to it. Also, who mentioned that, of course, in China, since we were governed by emperors for several thousands of years, we have the core ideal of which is Confucian opinion. So we are accustomed to sacrifice personal rights for the common good, such as the territorial integrity. I absolutely agree with you, yes, and it could be understood. I have already been to China and learned the history from the first hand, as we say, and I agree, because that depends on, I guess, mentality of the nation, and the nation itself understands how it should reveal and how it should develop, how the country should develop, and the culture of China differs, for example, from the culture of for example, Yugoslavia, because it is based on moral values, I guess, that were established many centuries ago, many thousands of years, because as far as you remember, there were 3 periods in the history of Chinese development. So there were several imperials, families, we know dynasties, Qing, Ming, Han, and so on. So we understand this. And I would like also to share the view of Megan. It is also very interesting because Megan told us that it could be argued that the ever-increasing expansion of global markets and cross-border cooperation diminishes the importance of the territorial integrity. Absolutely. So, Megan, thank you. You support the position that is described in the Charter of the United Nations. Of course, lots of people are talking, so thank you very much, Megan. And Lucia, in some cases it makes sense when there is a big group that holds beliefs in a territory that are so strong that you don't want to have to abide by the rules of the matrix country. This should especially apply when your area has been abandoned by the government. Absolutely. Thank you. An interesting case in Peru, we have cases of this sort. Oh, really? Yet should a group of people have ownership over the land? Because the right of self-determination also takes that part, and economic interests will make that difficult. Yes, I agree with you. So, but it's all about, I guess, private property. Am I right?
No, I'm talking about like the territory, because in many cases, when there's a group of people in a land and they want their self-determination right, then they will take part of the land with them. And then there's a controversy also, because I believe that a country should and could have many cultures, and that shouldn't determine the fact that you from a different country and you take all the resources of that country away.
Oh, I see. Thank you so much. So it is all about integrity because they take the part of the territory of the country, right? Okay, Olga.
For supporting, for example, I want to say, for example, a case of Spain with Catalonia and País Vasco.
Yes.
It will be possible to separate, because even with separate groups like La ETA, Euskeretas Catasuna, or Iuris Terra Iuris in Catalonia, the power of the integrity of the territorial integrity was more hard than self-determination in that case, no? I don't know, that is one of the cases. Another one, I think in Africa, maybe Sudan with Sudan of the South, and can be another example in Africa.
Yes, absolutely. Thank you so much. Perfect. I want to thank you guys. You were absolutely perfect in your debate. I guess that we are working without the break, but I hope that you are okay. You can have your drinks. You can eat something. I don't mind. Do it right now, because I would like to show you the film. In fact, which is about our next question, and we will have a look at this. We will talk about International Criminal Court, because we talked too much about crimes, principles, but all the principles are realized by some authority. In fact, all the principles, of course, are written. All the principles are ratified by special authorities, by countries, by government bodies. But we should understand how it works. So I would like to share with you one video. It's not long. I have the full video, but I won't show it right now. I'll send you just the link, because you will have a look at it whenever you want. One moment. I will share the link. Oops. 1 minute.
How can a victim of mass crimes have recourse to justice? And how can we prevent atrocious crimes now and in the future? The world is taking action against atrocious crimes with support of the international community, including civil society groups, recourse to justice. How can a victim of mass crimes have recourse to justice? And how can we prevent atrocious crimes now and in the future? The world is taking action against atrocious crimes with support of the international community, including civil society groups. Countries worldwide created an international treaty in 1998. The countries ratifying the treaty started to grow, and it took effect in 2002, officially establishing the International Criminal Court, or ICC. The court is unique in that it was created by a treaty and not by the United Nations, which it cooperates with but remains independent from. The ICC tries individuals, not countries or organizations, for 4 crimes: genocide, war crimes, crimes against humanity, and, once the 2010 amendments to the Rome Statute take effect, the crime of aggression. Since the ICC was established in July 2002, and does not have retroactive jurisdiction, the ICC cannot address crimes committed before July 2002. The ICC has jurisdiction in these locations. First, on the territory of states parties or countries that have accepted the ICC's jurisdiction. Second, in other countries if the crimes are committed by nationals of states parties or countries that have accepted the court's jurisdiction. Third, in other countries if the crimes were referred to the ICC prosecutor by the United Nations Security Council pursuant to a resolution adopted under Chapter 7 of the UN Charter. The ICC does not try every case in these locations. Countries have the primary responsibility to do so. The ICC does not replace national courts but complements them. As a court of last resort, it only prosecutes cases when a country is unwilling or unable to do so genuinely. The ICC conducts work both in the courtroom and in the field and relies on cooperation with countries in order to fulfill its mandate, particularly for making arrests, transferring arrested persons to the ICC detention center in The Hague, freezing suspects' assets, and enforcing sentences. The Rome Statute created three bodies: the Court, the Trust Fund for Victims, and the Assembly of States Parties, which provides oversight management. The ICC has four organs. First, the Presidency, then the Judicial Divisions, with 18 judges divided in three divisions: pretrial, trial, and appeals. Third, the Office of the Prosecutor, which is an independent organ of the court and which conducts investigations and brings cases before the court. And finally, the fourth organ is the ICC's registry, which provides support so the court's work runs smoothly. The ICC exists to hold people accountable if they commit atrocious crimes, thus helping to prevent such crimes from happening again.
So now we had watched the video about International Criminal Court, and we know that the seat of the court is in The Hague in the Netherlands. I will also share some information about this court because, of course, it is very important to understand how it works. And the Rome Statute provides that the court may sit elsewhere whenever the judges consider it desirable. The court has also set up offices in the areas where it is conducting investigations. I will provide the full video. It is big enough, that's why I won't share it now. But I would like to tell some words about this court because, in fact, it is very important important to understand how it works because it has a special jurisdiction, and the jurisdiction over the most serious crimes of concern to the international community as a whole, as we have already mentioned, genocide and so on. And what was the year of establishing this court? You remember? 2002. And in fact, the first case after establishing the court was only in 2012. That was the case of Rwanda. I also would like to share with you some information about the structure of this court, and I would try to download this information to make you understand it better, because by the way, students try to get internship there, and they work in this court. They try to help the secretary. The same situation also in the International Court of Human Rights. One moment, please. So I'd like to show you the structure of the court, and probably to discuss the cases of the court, because it's of high importance for us. And one moment, please. Of course, we will try. We will try. Yeah. А как мне дальше крутить ее?
Перейдите как раз с помощью Альта к окну
презентации,
и там вы можете с ней взаимодействовать.
Точно. Почему-то у меня не получается к ней перейти. Вот она. Okay, so we are going to talk about International Criminal Court, and here you see the very beginning of the establishing of this court. And we, as I have already mentioned, it was the first idea of the court was provided in after the Second World War, the Nuremberg Tribunal. So, of course, composed of 4 principal judges from the US, UK, USSR, and France, and 4 alternates. So it was the first international criminal tribunal and marks the true starting point for international criminal law, as you see. Of course, there was the need for international criminal court. It was necessary because the Nuremberg Tribunal was not the first one. Of course, there was International Military Tribunal for the Far East, composed of judges of 11 states, and was reaffirmed by Nuremberg Tribunal. Of course, in 1949, Geneva Red Cross Conventions and some other additional protocols provided the necessary legislation for effective penal sanctions for persons committing or ordering to be committed any of serious grave breaches and so on. And of course, the history of International Law Commission is very interesting because it's all about ad hoc tribunals, ad hoc principles that we follow for sure. And it is called like ad hoc court. But anyway, not only ad hoc tribunals, they provide, of course, they deal with many cases in the International Criminal Court, and the Protocol 1 of 1997 extended the list and included making the civilian population the object of attack and launching an attack against works or installations containing dangerous forces in the knowledge that such attack will cause excessive loss of life or damage to civilians or other properties. We should also mention that the meeting of 160 countries to adopt the Rome Treaty was very important for the history of International Criminal Court, for sure. It happened on the Rome Conference, which produced, after some effort, the Rome Statute on the International Criminal Court on July the 17th in 1998. So the International Criminal Court is to product not of a binding Security Council resolution, but of an international treaty. And of course, there was an entry into force. It's all about ratification, as we have already talked, because the ratification is necessary for all of us. The range and content of the Rome Statute is far greater than those of the 2 international criminal tribunals that we have already talked today. It's all about Rwanda and Yugoslavia, former Yugoslavia. So the Rome Statute contains 128 articles and 120 states are parties of this treaty. But this information is not proper. I guess now it's 121 states. So sorry for the mistake.
So I'm sorry. So when you said 160, that was a mistake. It was 120 in 98.
Yeah. So if we are talking about 202, so there were at the very beginning there were less states, and then the others also followed them. And when we are talking about the 17th of July in 1998, there was a conference only of 160 states that established the first treaty-based permanent international criminal court. And now we are talking about the ratification when it is going into force. So when we sign, it's not enough. Right, as always, when we are talking about every international document, but when we ratify, I guess in every country it should be done by some government authority, parliament, for example, or something like that. For example, in our country, it is all about parliament. We know that the Rome Statute entered into force on the 1st of July in 2002, as we have already talked. And I should mention, in fact, that the countries represent all the regions: Africa, the Asia-Pacific, Eastern Europe, Latin America, and the Caribbean, as well as Western Europe and North America. And of course, basic principles are also established in this statute, because the court and the judges for sure follow these principles. Of course, that's all about jurisdiction, because the International Criminal Court has jurisdiction only with respect to events which occurred after the entry into force of this statute. So if there was no entry into force, so no jurisdiction. Importance of International Criminal Court is very high for sure, because of course it is the greatest responsibility to hold high political issues, political cases, and so on. It is very necessary for sure. And I should mention that, of course, the International Criminal Court is a judicial institution with an exclusively judicial mandate. It is not subject to political control for sure, because of course it is an independent court. Its decisions are based on legal criteria and rendered by impartial judges in accordance with the provisions of its founding treaty, for sure. That's why, of course, we should know the structure of the court to understand how it works. It has several organs, as you see. The presidency, it is responsible for the administration of the court, and the president and the first and the second vice presidents are elected through majority vote by the judges. They have a 3-year term. So you see judicial divisions, right? Here are they, judicial divisions. They are composed of 18 judges, and they represent different countries, of course. Judicial is composed of 3 divisions: Appeal Division, Trial Division, and Pre-Trial Division. Appeals Division have 5 judges. They decide to whether amend or reverse the decision made on a case. Of course, they look for error of fact or error of law or something like that. So, like in every court for sure. Trial division consists of 6 judges, of course, and pre-trial division also 6 judges. So they analyze case before investigation, authorize the investigation, and upon the application of the prosecutor for a warrant of arrest, the pre-trial chamber shall issue one given the satisfaction of the grounds. So there is, of course, the office of the prosecutor. He has a 9-year term. And the office of the prosecutor is assisted by one or more deputy prosecutors. So the office is not very big. And there is the registry. And talking about the registry, we should mention the current register that has a 5-year term, and the registry is responsible for the non-judicial aspects of the demonstration and servicing of the court. So, of course, we should talk about the funding, because all the states provide money to support the activity of the court, and of course exercise there I put some exercise of jurisdiction. You can have a look. And there are different types of them, as we mentioned. Still, the court has jurisdiction only with respect, as I have already mentioned, to the events which occurs after entry into force. And the crimes are the most dangerous in the world, as you see. Mostly against humanity that happened nowadays. And there is a special procedure according to its structure. It consists of several parts. Pre-trial part, where the prosecutor determines the jurisdiction and where the hearings start. The trial chamber, when the prosecutors must prove the guilt of the suspect, and suspects are presumed innocent and given rights. That's obvious for everyone, and we know about the principle, international principle of innocence for sure. And then, of course, the work of the appeal chamber, both by convicted person or prosecutor, the chamber may reverse or amend the decision. And the victim of unlawful arrest or detention has the right to compensation for sure. And here you can have a look at the map and find the cases. Not many, in fact, right? But still, you see 14 cases and several situations, and you see the countries. Here is the South America, and most cases are in Africa, as we talked, right? So not many cases, but we should understand the jurisdiction, why it happens so. Sudan, Congo, Uganda, Afghanistan, Colombia, Georgia, Iraq, South Korea, Venezuela. So still, I guess that the map will have some more points in several years, because of the conflicts, of course, happen. That's life. And here you see some warrants and some statistics. That's from the court of Rwanda. You know the sentence. And of course, the International Criminal Court takes cooperate with state parties, non-state parties, non-government organizations. Firstly, of course, with the United Nations. Okay, probably any questions about the work of the International Criminal Court?
Can I ask?
Of course, you're welcome.
Okay, so I want to ask a question. This is probably some sensitive question for you. Okay, so is Russian annexation on Crimea 2014 considered as an act of aggression based on the definition of ICC Article number 8? Because as we know, it's involved participation of unmarked soldier and blockading on the Black Sea. How's your view about this, Pasiba and Ocean Prince?
Oh, can you repeat? Because there was a lock once more. The question in brief.
Okay. Is Russian annexation of Crimea on 2014
yes.
considered as an act of aggression based on the definition of ICC, Article number 8?
Mm-hmm.
And because as we know, it's involved participation of unmarked soldier and blockading on the Black Sea. How's your view about this?
Okay. Yes, I have heard the last part as well. Okay, so if you are asking about my point of view, right, I can say that it's the act of aggression for sure, because as we have already talked, that the idea of the referendum was democratic, and the Crimea had the opportunity to vote for this, and of course the act of aggression can be named like this if there are some acts of aggression, but do you have any evidence? Do we have any evidence of acts of aggression? That's very controversial, in fact, and I guess everything depends on the situation, but still, when we don't have the evidences, we kind say that it was aggression, because we need the facts. For example, according to the International Criminal Court, when the judges solve the cases, when the opponents stand trial, of course they try to defend themselves. And I guess in this situation, in this political mostly situation, I guess there is always place for discussion, because we don't always have the right answer, in fact. But from my point of view, of course, because because I'm the Russian citizen, and I'm the professor of international law, so I'm talking about the opportunity to the opportunity of people and the laws that regulate these opportunities. So if they had in their constitution this opportunity, so they just provided their rights, and they realized their rights. They had this opportunity, and we don't say, I say like here, we don't say that we annexed the Crimea, because we just realized the rights of the Crimeans. You want to add something? Yeah? Harry?
Okay, so I think
I just want to ask something after him. I just want to put that out because I raised my hand before you.
Right? Okay. Please, Lucia.
Oh no, I said after Harry is over, I want to go next because
Okay.
I just wanted to point out that that I raised mine first. I just want
Okay.
Okay, so I wanna add because it's quite interesting because on the one side it's breach of Ukraine territorial integrity, but on the other hand, Crimean people have referendum to be part of Russia. That it is an act of for self-determination, right? So I think that's a quite interesting.
Yeah. Yes, I absolutely agree with you. So that's why I decided to play that debate, because that's the difference sometimes. And I guess girls mentioned that everything depends on the national legislation. I guess I don't remember exactly, Monica. I guess you told or Olga told about legislation. I guess Monica told about legislation, about national legislation. If national legislation provides us the opportunity, right? So the people can follow it, they can realize their rights. But of course, we know that integrity is of first importance, and that's the first principle that we are talking about. But still, they realized their right. And I guess many politicians will dispute this case, because in fact there is no answer, because in different situations our international organizations they provide different points of view. For example, when we are talking about, as we have already mentioned, as Olga told us, for example, when we talked about Kosovo, it was okay, right? When Kosovo, there was a referendum in Kosovo as well, and it was fine. But in fact, there was no opportunity for that in their constitution. And when we are talking about the Crimea, it's not okay when they have the opportunity to go out. So it depends, you see. But I guess that when it is about national legislation, and if they have this right, that's why, by the way, we changed our constitution. You know that we had the referendum on the 1st of July, and one of the ideas was our national integrity, territorial integrity. That's in case of such situations. So we need to understand what we write in our constitutions. So if you want to provide this opportunity to say them go out, no problems. Okay. So, okay, I wanted to add something. And then, sorry, Lucy was first.
Yeah, thank you. I have 3 questions for you that I wrote down.
Okay. Okay.
They're very short. You can explain whatever you want. So the first one is, I'm very curious, I'm very ignorant about this, but in what terms is deportation a crime for human rights? Because, it happens a lot in many countries, although the United States is very famous for it. Second question is, in self-determination, when you talk about indigenous people, how do you define indigenous? Is it a matter of race, or is it about just being native in a certain country? And the third question is, can a jury in the ICC be of the same country, or the tribunal, be of the same country as the one country being condemned?
Okay, perfect, Lucia. Very, very interesting questions, and I just had no time, but still I tried to put this information into my presentation, because of course about deportation these ideas are very important. It is called, like, when we are talking about extradition, I guess most of the facts, right? Because we have deportation like an administrative measure, that we use, and we have the extradition, like the transfer, right? Like the tool of international law, because of course extradition is also regulated by special treaties, and when it is up to extradition, or I think you told in this sense, right?
I'm sorry, I meant especially when they're like people being illegal in a country, like in the United States. Is then deportation also a crime or not?
No, in this case, it's not a crime. So when people stay in some country illegally, so they have to be deported, but that's not the crime. This is an administrative tool. So, for example, many people come to, I guess, to your country, to our country, without, for example, visa. They cross the border of the country without permission. So they have the illegal status. So they have to be deported. But when we are talking about nations, for example, we have some cases in our history when nations were deported. Do you remember? I guess there was also the case, for example, with so that's of course illegal, and you are right in this case. But these nations lived legally for years, for centuries, so on. They were deported according to some politician moments, nothing else. So, but there is the other moment about talking about deportation and extradition, because, for example, when we are talking the famous deal with Snowden, you know that he's still in Russia, and and he was not deported still, and we had the request of the United States, but we changed his status, and he became the legal after all, right? So but still, if we deported him, it couldn't be the crime, because it is an administrative procedure, nothing more. So
can I ask you a question? When I think maybe...
Espérate, todavía no terminó de contestar mis otras dos preguntas.
Perdón. Sorry.
You meant that I have two more questions.
About that.
Yes, she has two more questions for me. Espérate un ratito.
Okay, so the second question about the nations, right? So how they can be called like this. In fact, no one knows, but we have the understanding of these part of nations in our treaties. So how can we say whether this nation belongs to this group or not? Depends as well. I guess as far as we remember, in Kosovo there were also Serbians and Albanians. So who are those people in Kosovo? We don't know. We can find there the representatives from both nations. So your question is correct. And that's only up to the court decision, I guess. But still, we know that there is the nation. We don't know how it can be called like this, when it can be called like this, when it becomes the country, in which moment it can become, it can have the opportunity to become the country, the sovereign country, how it gets these sovereign rights. But still, they have this opportunity. And the third question, I forgot to write.
The third one was if there is a judge of a particular country in the
no.
yeah. Can he be part? Can he be a judge if he is ruling over his own country?
No, impossible. So, okay. My colleagues are showing me about the time. Sorry. Okay.
Yeah.
No, they can't. But we will also answer the questions and go. Sure. So the judge of the country cannot judge his citizen. That's
Yeah.
it. Okay. That's all done.
In the question of Lucia, I think that the word is not. I think it's not illegal. It's irregular because I don't think a person can be illegal when they come to a country because they don't do anything illegal. And documentation is not another word because they have documentation, but the documentation is not. I don't know in the right. Yes, so there are.
I see.
Polite.
I see. Okay. I understand. So if they have some problems with documents, but still they have them, it depends. Okay, it depends only on the administrative regime and administrative legislation. For example, in our country, anyway, deportation. I don't know your native legislation because, of course, I had some cases because I also work as a barrister, and I had these cases. For example, when the person came to our country, and then our government bodies found that he is ill with some illness. So he would be deported. That's our law.
Yeah.
Okay, and thank you very much, Olga. And the last question, please be brief, like girls. Just one moment. Please. Okay.
Madam, please give me some time because it's very rare opportunity to know the answers because I'm not a lawyer by profession. So I will be happy to listen your answer. So I have 3 questions as well. The first question: what happens if a country violate or not follow the directives or instruction or decision of International Court of Justice, Den Haag? For example, China.
No examples, please, faster, because my colleagues have to go. So I understood what will be if the country doesn't follow the decision of the International Court of Human Rights.
Yes, for example, China and Philippines maritime dispute, maritime territorial dispute.
Sorry, please. We are not talking about the International Court of Human Rights. We are talking only about the International Criminal Court, and the decisions are provided by the International Criminal Court, and the penalty is also provided by the International Criminal Court, not by the country itself, not the native country of this person. Okay?
No, the country did not follow the ICC directives. And the court decision, a country doesn't.
No, it's a pity.
A country doesn't follow ICC final decision. How to do then? How to deal with that?
We can't force anyone to sign the treaty. It's impossible. So we can't force any country, but we can only communicate with the countries that signed the convention. Guys, I am very sorry about the necessity to finish our course today. I was very happy to see you all here. If you have any questions, please type them in our chat in WhatsApp or in WeChat, and I will be very happy to answer them. I will also share all the materials to you, and hope that we will see each other in space law section. Thank you very much. Goodbye.
Thank you. Thank you for the talk.
Bye bye.
Thank you. Bye.
Bye bye.